or welcome our guest on the program. He's a regular speaker and contributor here at the IHC. He's a friend of the IHC's, Chris Condeluci, principal and sole shareholder with CC Law and Policy. Chris, good morning to you.
Hey, guys. How you guys doing today?
We're doing great. Great to have you on the program. Happy 4th to you and your family.
Yeah, indeed. Happy Friday.
Yeah. Hey, Chris, give our audience, before we kind of jump into the weeds here, and there's a lot of weeds here, as you know better than anyone, give us a little background on yourself and on CC Law and Policy, if you would, for our audience.
Sure. No, I appreciate that. So, to everyone, you might have heard me speak before, and I appreciate Doug, you and others, including me, in many of the conferences that you put together. They're fantastic. So I'm an employee benefits attorney by training. Had the opportunity to work for the Senate Finance Committee during the development of the ACA, and as a result, participated in drafting portions of the law, including the ACA exchanges, all the insurance market reforms, and all of the new taxes under the law. I left the government in 2010, September 2010, and now I have my own legal and policy practice where I provide, legal counsel on matters relating to the ACA, be it employer compliance, be it understanding the insurance reforms, regulations affecting insurance carriers as well as the ACA exchanges. But I also do some policy work, policy analysis, working with folks on Capitol Hill as well as the federal departments. For all intents and purposes, mostly ACA related, a little bit benefits related like HSAs, tax treatment of health insurance, but primarily ACA related.
That's great, Chris. I appreciate that. And we got a lot going on here. Let's talk about the individual market a little bit and get kind of your clarification on why the federal departments prohibit the purchase of an individual market plan on a tax-free basis.
Yeah, and it's a good question. And, it's been a question that's been out there since, I would say 2011, 2012, and really the federal departments responded to this question of whether an employer can provide tax-free reimbursements for the purchase of an individual market plan by issuing guidance. And Treasury, HHS, and DOL, which I'll refer to as the quote-unquote federal departments, have actually issued 6 pieces of guidance, really, again, dating back to January 2013. The federal departments also codified this guidance in regulations. And essentially, the federal departments have said that if an employer does provide a tax-free contribution or reimbursement for the purchase of an individual market plan, that will trigger a $100 per day per violation excise tax. Now, the big question, has been, why did the federal departments, and really this goes to your question, why did the federal departments issue this guidance in the first place? And what's kind of interesting, and I don't want to get too far in the weeds, but pre-ACA, there was a prohibition in the law under HIPAA. I think most benefit practitioners know and love HIPAA, or maybe not love HIPAA because it's a very complicated law similar to the ACA. But under HIPAA pre-ACA, generally speaking, you could not give an employee a tax-free contribution for an individual market plan. And that was generally prohibited because under HIPAA, group health plans, the premiums could not vary based on health status. And pre-ACA, as we all know, carriers in most states could underrate based on health status such that the premiums for these individual market plans would vary based on your health status for an unhealthy person versus a healthy person. And the departments back then took the position that if an employer was contributing toward the purchase of an individual market plan, that made that individual market plan a quote-unquote group health plan, thus subject to HIPAA, thus running into the prohibition that I discussed. Well, ACA comes along, no underwriting based on health status. So carriers are prohibited from varying premiums based on health status. So the HIPAA problem goes away. And most practitioners like myself back in 2011 said, wow, this is great. Folks can now purchase an individual market plan on a tax-free basis. Well, the federal department still didn't like that, still didn't like the purchase of an individual market plan. So they created a legal fiction, as I like to refer to it, suggesting that a reimbursement arrangement, one, is a group health plan, and that group health plan is subject to the ACA market reforms. And last point, because I'm delving into the weeds probably more than I would like, but last point, when it comes to this reimbursement arrangement being a group health plan, the whole reason why the federal department says it violates the ACA market reforms is they say that the reimbursement up to the premium amount results in a quote-unquote annual limit on the dollar value of essential health benefits. And if the premium or the reimbursement amount has an upper limit by definition, it violates the ACA's annual limit restriction. And thus it triggers this excise tax that I spoke about beforehand. And that's essentially the why we have this legal fiction and this prohibition that remains for employers wanting to reimburse their employees on a tax-free basis for the purchase of an individual market plan.
Do you see, Chris, last kind of point on this, do you see any future changes and revisions, on the table and that can be coming forward to kind of, change this?
Yeah, and the reason why, I wanted to jump on the show today and talk to folks and answer that question particularly is last week the House of Representatives actually passed legislation that would reverse the federal department's guidance, as I described, for employers with fewer than 50 full-time equivalent employees. So in essence,
is this the HRA bill, Chris? Is this the HRA bill that you talk about?
Correct. So it's the actual number is HR 5447, so 5447, affectionately referred to as the HRA bill.
So what does this do, Chris? What is this?
So essentially the legislation turns off the definition of a group health plan that I described for these reimbursement arrangements. So it essentially reverses the federal department's guidance as it applies to employers with 50 or fewer full-time equivalent employees, thus meaning these small employers can actually now, pause when I say now, if the legislation becomes law, because it has not become law as of yet, but if the legislation becomes law, these small employers will be permitted to reimburse employees on a tax-free basis for the purchase of an individual market plan.
That's interesting. What do you, you're kind of there and living and breathing on the Hill. What do you think the opportunity is for this to become law, and if so, when?
Yeah, and it's a good question, and the truth, that's why I wanted to come online, because a lot of folks out there think that this legislation already passed, is already part of the law, and that's not the case. It has taken a huge step forward with respect to the House of Representatives agreeing to this legislation on a bipartisan basis. And to your question, this now goes over to the Senate. And the Senate has to consider it and actually approve it before it could go to the president's desk to be signed into law. Unfortunately, it appears that the legislation is running into a bit of a buzzsaw in the Senate. So it doesn't appear, at least at this stage, that the legislation will pass the Senate between now and election time. However, we're likely to have a quote-unquote lame duck session, which will occur after the election, where typical end-of-year legislation or legislative activity occurs, and a lot of, let's say, bipartisan provisions that did not move during an election year are more likely to move, and it is actually expected, I give it a 60-40 chance, that this legislation is included in an end-of-year legislative package, ultimately approved by the Senate and the House, and ultimately signed into law by the President, with probably an effective date of January 1, 2018.
This would have a big impact on kind of transferring to our next discussion. We talk a little bit about private exchange that you've been intimately involved with, because when it comes to the small group and the opportunity around small group and executing a defined contribution strategy, via an exchange, is pretty important, right?
Yeah, it goes back to, the desire of small employers, wanting to provide this type of flexibility to provide a contribution to their employees so they can help their employees purchase health coverage. But many small employers are struggling with actually affording health insurance due in large part to the ACA market reforms in the small group market, which has increased premiums markedly. So this will just add some additional flexibility or provide some additional flexibility to those small employers that want to help their employees better afford and purchase health insurance.
And when you look at the small employer market too, is we have an increasing challenge to retain skilled workers. This is pretty important to help those small employers provide some form of benefits to their employees and keep them on board with them versus losing them upstream to a larger company.
Yeah, no doubt. And that's where a lot of the folks in the small business community, have been advocating for this change, for this reversal of the federal department's guidance, at least as it relates to small employers. And again, I just want to emphasize to everybody on the listeners today that this legislation is only applicable to employers with fewer than 50 full-time equivalents. And the reason why that was put into the law is there was some concern about this legislation impacting directly the ACA. And so this definition tracks the definition under the employer mandate.
Right. Let's turn the chapter a little bit. Let's talk about private exchange a little bit. Are policymakers even aware of private exchanges and the features of a private exchange?
It's an excellent question, and my answer is yes. And I've had many of conversation with folks on Capitol Hill about private exchanges, and myself, including other industry stakeholders, have had conversations with congressional staff. So actually, they are indeed aware of private exchanges, and at least, for example, when it comes to congressional Republicans, again, are aware and actually very much would like to leverage the features that a private exchange offers. And, for example, the white paper that the House Republicans recently released as an ACA replace or ACA modification, while that white paper doesn't quite speak to private exchanges, staff that I've spoken to and staff that have spoken to other industry stakeholders continue to say that they would like private exchanges to be the distribution channel of choice for example, individual market plans to which a tax credit will be available to certain individuals, as well as promoting private exchanges in the group market space. So policymakers are aware, and it's just a matter of the politics allowing some sort of, let's say, proposals to enable private exchanges to be that distribution channel of choice.
What's the policymakers' overall feeling and even awareness to HSA eligible plans and health savings accounts?
Well, it breaks, really along party lines, sadly, right? Yeah. And we've known that because that's been the case, since 2003 when HSAs came into the law. And on the Democratic side, sadly, we're hearing the same, and I say this sadly, this is from my point of view, of course, we're hearing the same response from congressional Democrats that HSAs are really only geared toward upper income folks. Upper income folks, can take advantage of the tax benefit, and that's to the disadvantage of lower income individuals. And there's some resistance on the Democratic side to HSA eligible plans. On the Republican side, however, we've seen legislation year over year promoting HSA eligible plans. In the recent House Republican white paper, there are proposals to expand HSAs. Chairman Hatch, chairman of the Senate Finance Committee, has legislation out there which similarly expand HSAs and the ability of individuals and employees to enroll in an HSA eligible plan. And I'll say this one last thing back on the kind of the Democratic side. There has been some guidance issued by the Department of Health and Human Services that may adversely impact HSA eligible plans, at least as it relates to those plans being offered on the ACA exchanges.
Mm-hmm. That's interesting stuff. Talk to me a little bit about the Cadillac tax and where you see that today, and where do you see that heading? I mean, are we going to keep kicking the can down the road, or what's your view on the Cadillac tax?
Yeah, I've consistently stated that I believe the Cadillac tax will be repealed. I believe it will be repealed regardless of who wins the White House in November. But I also have consistently stated that I believe another limitation on the tax preference for employer-sponsored insurance will replace it. So the question is what will that limitation look like? And then what exceptions to that new limitation will be put into the law? For example, as it relates to the Cadillac tax and at least consumer-driven health plans, as I think most know, employee contributions to an FSA and employee contributions to an HSA are counted toward the Cadillac tax. And there have been efforts on Capitol Hill to try to provide an exception for those employee contributions to an FSA as well as an HSA. And I would say that those efforts are actually making progress. So much so that, again, referencing the House Republicans' white paper, which in that white paper they replaced the Cadillac tax with a direct cap on the exclusion. In that white paper, they specifically say that employee HSA contributions will not be counted toward that new limitation on the exclusion. So I do believe, even although Democrats have not spoken publicly about the issue, that if they were to win the White House or if they were to win back the Senate and they were to repeal the Cadillac tax, replace it with some sort of limitation, I'm cautiously optimistic that there would be some exceptions provided for contributions to consumer-driven health plans.
Yeah, that's interesting. That's good news for for many. Hey, Chris, it's been great having you on the program. I want to give you an opportunity to provide any final thoughts to our audience, if you would, please.
Yeah, just one detail back on this HR 5447, the HRA bill. Contributions are capped at a specified amount. An employer cannot be also offering a group health plan and offer these tax-free reimbursements to folks. So it's an all-or-nothing proposition. You either are offering a group health plan or you're offering these tax-free reimbursements for an individual market plan. Those are some details that I think folks out there need to know. And if you ever have questions regarding some of the details, feel free to get back to Doug and Ron, as well as some of the other practitioners out there that play in this space.
Yeah, hey, Chris, thank you for that. Let our listeners know how they can get in touch with you, please.
Well, my email, I guess, is fairly easy. It's just Chris at cclawandpolicy.com. cclawandpolicy.com. It's all one word, and the "and" is spelled out. And my phone number, which I don't mind you all giving me a call, it's 703-209-0690. Again, 703-209-0690. Happy to talk to anybody about all the fun stuff that we just talked about today.
And just to remind my audience, too, that Chris will be with us speaking at Private Exchange Forum Baltimore in September, so you can come and talk to him personally there and listen to him there. Chris, great having you on the program as always. Have a great 4th, and we'll talk to you again real soon.